Is a deed of absolute sale of real property that is not notarized valid? The answer is yes. Article 1358 of the Civil Code requires that the form of a contract transmitting or extinguishing real rights over immovable property should be in a public document. Under the rules of court, documents acknowledged before a notary public, among others, are private documents, while the unnotarized deed of absolute sale cannot be considered a public document, but only a private one. However, the failure to observe the proper form does not render the transaction invalid. It has been settled that a sale of real property, though not consigned in a public instrument or formal writing, is, nevertheless, valid and binding among the parties. For the time-honored rule is that even a verbal contract of sale of real estate produces legal effects between the parties. Article 1358 of the Civil Code, which requires the embodiment of certain contracts in a public instrument, is only for convenience, and registration of the instrument only affects third parties, and non-compliance therewith does not adversely affect the validity of the contract or the contractual rights and obligations of the parties thereunder. Otherwise stated, the deed of sale of real property is binding between the buyer and the seller, even if the contract has not been notarized. It will be difficult, however, to register the certificate of title of the property under the name of the buyer, considering that the Registry of Deeds, as well as the BIR, require the deed of absolute sale be notarized. In case the seller refuses to have the deed of sale notarized, the buyer may compel the seller to have the deed of sale notarized, even after the execution of the document, by filing the appropriate action in court. Thank you for watching this video.